I now invite our panelists to the dais. A quick round of introductions of our esteemed panelists today. We have with us, of course, Professor Madhava Menon, who is the founding chairman of National Law School, Bangalore, as well as the National University of Juridical Sciences, Calcutta. With about 5 decades of outstanding contribution to legal education in the country, he was awarded the Padma Shree in 2003, making him the first law teacher in the country to be a recipient of that award. Professor. Joining him is Mr. Amit Kapoor, senior partner at J. Sagar & Associates. Mr. Kapoor is a well-known name in the areas of infrastructure development and regulatory mechanisms, having advised and represented various state and central government and government bodies on such matters. Next, we have with us Mr. Kailash Karthikeyan, a policy consultant and attorney at Gestalt Consulting and Research. Prior to this, he worked as the attorney at Microsoft India with a focus on competition law, intellectual property law, and public policy, where he was closely involved in ensuring favorable outcomes for Microsoft before the Competition Appellate Tribunal. We also have with us today Mr. Ramji Srinivasan, senior advocate with the Supreme Court of India. A senior counsel in commercial and regulatory laws in India, Mr. Srinivasan has successfully argued some of the most well-known cases, commercial cases in India, including matters on telecom spectrum, airport tariffs, and electricity, as well as the very first appeal in the new insolvency laws before the NCLAT. He was recently awarded the Competition Lawyer of the Year. Our final panelist today is Professor V.C. Vivekanandan, founder dean of the School of Law at Bennett University. He has more than 2 decades of teaching and research experience in legal education and holds a PhD in IPR and a master's degree in the field of corporate law and public administration. I now request Mr. Lieberhan to come up and moderate our panel discussion today.
Good afternoon, ladies and gentlemen, my fellow panelists on the dais. They've all been introduced by the compeer, so no fresh introductions are really needed. This stage has really been set for a very meaningful discussion. We have experts, professionals, successful ones, with long years of experience in their respective fields to add to the issues to be addressed here. Essentially, it's about the initiative that has been undertaken by Manupatra, which is, by all accounts and without any doubts, a very needed one. We heard the opening remarks from Justice Lokur and Justice Geeta Mittal, and both of whom have appreciated this beginning as a felt need in the profession. I remember distinctly when I joined the civil services and some years into the service, when I was handling one of the desks which dealt with establishment, essentially personnel, general administration, and people used to come to me and said, we are short of people, short of hands, but please, sort of give us good people, good hands, competent people, otherwise don't, because we are better off without them. And I used to wonder, where is this factory that produces good people, the government doesn't have one. After all, we have a recruitment system which is fairly transparent. Good people have to evolve, really speaking. Organizations have realized this over the years, and the fact is that good people don't come in any shape or size. They evolve in the environment. And I think what the environment can do is to have a facilitative ecology, ecosystem by which the good people actually can display their excellence, learn, and become competent people. That's the only way you can get good people. And so also in professions, whether it's the doctor's profession or the lawyer's profession or the chartered accountant's profession, there are good people who are studying law, there are good people who are studying medicine, etc., but they have to evolve into competent professionals. And the question is that the environment needs to be facilitative. There has been a deficit, as Professor Menon mentioned, about the practice-ready lawyers, sort of not emerging from the law schools. It can't happen. It doesn't happen. The nature of the legal education, of course, has undergone vast changes. But despite the fact that there are still deficits, it used to be at one time a 2-year course after graduation. Then it became a 3-year course after graduation. And now, of course, you have 5-year courses. At one time, it was a profession of last resort. Today, it's a profession of choice amongst youngsters. And that is the huge transformation that has happened in law. But in any case, I don't think we are going to talk about the content of legal education. That we can leave for another occasion, etc., because whether it can be transformed, whether it can be changed, whether it, sort of things can be introduced, that's another matter. Basic question is that today the deficits that the graduate faces, or even as a student, how does he acquire that skill? Where does he learn that additional need to become an accomplished lawyer of assistance to the clients, etc.? And that is what is going to be, the core focus of our discussion. And I requested our panelists also to look at this dimension. It goes without saying that, as Fali Nariman, one of the great lawyers, said that it's the school of hard knocks where you learn the most. That is true of the professions, it's true of life as well. But that apart, if the knocks could be softened a bit, even a trifle, by getting access to information, access to knowledge, access to, sort of the way to do things, access to skills, as is the intent in this initiative, I think a huge purpose would be served, and there'd be vast segments of population that would really benefit. But in any case, between these two extremes, or the truisms about, the effort is now to address the lack of preparedness of a law graduate to contribute his services to the profession. I think we will go in order from the left-hand side to the right-hand side. The panelists would share their perspectives, their beginning time, their beginning years, sort of the kind of, did they look at a mountain that needed to be climbed, and, sort of how steep was it at that point of time, and, the distance that they have traveled, and what would they like to advise the LawSkills team as to what dimensions can be added in this. The best thing, of course, I like about the legal profession is that no matter how many palkiwalas and sitalwads and sort of salves and siravais that the profession produces time after time, there is always room at the top. This is one profession where the sky is the limit, and it's never full. So be that as it may, I'd just like to add one thing that, yes, fame and name do beckon you, and it's yours, it's for the law graduates for the taking. But one thing that I'd like to add, and that is the dimension of ethics in the profession. No excellence can really survive without ethics, and that sort of needs to be cultivated and inculcated into people who are going to join this profession, because ultimately this is the one that's going to give you endurance, this is the one that's going to give you sustainability, and this is the one that's actually going to establish you, whether you are a lawyer of consequence or you are a lawyer of transactions. May I now begin from Mr. Kapoor? I think he would share his perspective from this end, and then we'll go to Ramji, and then Professor Vivekanandan, and then Professor Menon, and then Kailash. Mr. Kapoor.
Yeah. Morning. Perhaps I should say noon. I belong to the times that law profession, when we went to college, and Ramji was 1 year senior to me in law fac, when law was not the chosen option. When I was asked a question, why in the hell are you doing law? Didn't you get admission anywhere else? I had to tell them, no, actually in BCom honors when I was studying, I quite enjoyed the practice of the field of law, and I'm a first generation lawyer. And it was quite difficult for people to believe on face value. Well, we are in happier times where profession is of different demand in terms of youngsters. But along with opportunity comes challenge. And what I would share with you, I graduated in 88, so I'm talking 85 to 88. And now I've completed 29 years in the profession at the bar. The important aspect of success or failure, as I see it, is how deeply are you engaged with the reality of law not being an isolated laboratory experiment. Ultimately, as Roscoe Pound said, law is all about social engineering. Law is a tool, it's an institution, it's a mechanism of achieving certain ends. Law is not the end in itself. And given that it's law of human society, its applicability is in context of rights, obligations, duties, interests, distributive justice, welfare, and various other facets of human society, of a nation, of a global community. We heard from Justice Lokur and from Justice Mittal aspects of that. The challenge that we face and the opportunity lies within is that largely the way law is taught and the way law is practiced, it seems to gravitate more to Section 5 and Rule 32 as well as Article 59 rather than what happens to the person, the individual involved, the business involved, the child involved, and all of that aspects. So may I suggest that we should examine law as a facet of impact on society, impact on economics and finance, impact on political environment, and the environment itself. When you start looking at law from that angle, and if you see the list of topics that they have, I was most amused when I pulled Ramji's leg on that. There is one topic in the course on LawSkills, and I told Mr. Suri as well. It's a, I think, hugely underpriced course on how to work with senior advocates, only 1,000 rupees. But yeah, other than the swipe, the hard fact is that please consider that in a democratic institution, what is it that we have? There's an underlying social contract. From the time of caves, individuals came to live in organized societies. We framed certain rules for ourselves. With 125 crores, we can't do the plebiscite that you often find in smaller countries and communities. So you elected people to represent you. They made the laws. From the days of kings, you brought the constitution where individuals and communities got right against state which was otherwise at times seen to be despotic. And there were certain duties which were cast on the state. The directive principle of state policy, the fundamental rights, and the entire allocation of rights and duties comes out of that. And then you evolved a situation where implementation of laws, as enacted by the 545 worthies in the parliament or the state legislatures, was left to the executive. Now the transaction of work amongst these three institutions, the judiciary, the executive, and the legislature, is at the heart of rule of law. And there can't be an organized society where rule of law is not current with the current realities of the day. I'll cite one case which will make the point good. India still has the Indian Contract Act 1872 as the law in place. Section 3 and 4 talk about offer and acceptance and communication of offer and acceptance. And that is that in the good old days, I'm going beyond the Kabutar times, when you put a document in post and it was sent to somebody, once you sent it out, you were bound by your offer. And you got bound particularly after the person received it, you couldn't retract it. Once that person put his acceptance out, he got bound, and particularly so once the other person received it. And then came the good old case of Entos versus Miles and Govardhan Das Kedia, where we came to the world of telecommunication and instant communication. Now we are in the world of internet, where winks and clicks are the driving forces of transactions, where millions of trillions of dollars are transacted across the world. I mean, now today we are all living, courtesy demonetization, in the world of Paytms, etc. So given that reality, if we take away the fineries and the complications that some of us love to create around law, it is ultimately an institutional mechanism to try and ensure that people stay within their mutually agreed rights and responsibilities when they deal with each other. Now, whether these are corporations, their employees, their individuals, all of those are governed by the same principles. When we accept that as a reality, then how do you apply a section or a law or a legal principle to achieve the outcomes of justice? Inherently requires us as lawyers and judges who are on the bench to try and step into the shoes of the people who have come with a complaint. If a person lands with a grievance before a court of law, or for that matter in a mediation or a conciliation proceeding, and the other person comes across, it's a question of resolving that challenge. So you need to identify the set of facts, and when you start identifying the facts, you can't use the same old principles that existed before, when technology, the way of doing business, the way of dealing with each other has changed. So one challenge, and I was interestingly scanning through that, I remember having read, there was a judge, a law lord of England, Leslie Scarman. Leslie Scarman spoke in 1974 December and delivered the Hamlin's lecture, 26th lecture. They have an annual lecture, where he spoke to the legal profession in England saying there's a need to change. And his basic thrust was that there are challenges that are facing because of which the legal profession is stopping to become relevant. That thought came back to me because Professor Menon said to us that if we don't improve our legal education as we go along, we will start becoming irrelevant. It is already a challenge that at times disputes take 15 to 20 years. And a person who's perhaps retired at 60, as looking at getting his house back so that he can live in it, and facing a challenge in court, facing a daunting task of 10 years in court, starts looking at other ways of solving the problem. So what I'm bringing to you is the fact that ultimately ends of justice will have to be achieved in this context. I'll stop here because I thought that starting point I should put for my colleagues on the dais issues that must be addressed, whether it is continuing education or skill building. It has to deal with finding real solutions in real world rather than just legal principles which may not solve the problem. Thank you.
So thank you, Mr. Kapoor. Basically, I mean, he's cut to the straight to the issue at heart, and that is to bring your skills to converge, skills and knowledge to converge on the outcome, which is for resolution of the issues that somebody comes to you with. Thank you very much, and may I request Mr. Ramji now for his views.
I use this timer to warn Amit that your time is up. And I think that's what Deepak's been doing also. He's brought technology to all of us. But I'm intrigued by how Mr. Liberhan knew how to steer these proceedings. He's got two practicing lawyers on the left-hand side, and then he says we'll move from left to right, and he's got our guru on the right-hand side. So which means that all your mistakes will all be eventually solved by our teacher, Professor Menon. And we are so grateful, sir, to be again being with you. I was again amazed when Justice Lokur mentioned that even he has been taught by Justice Menon, Mr. Menon, Professor Menon. So which means that, well, actually that's real justice, isn't it? That is one aspect of the matter. The other is, I'm also very glad that Deepak has designed this course, and Priyanka, and termed as LawSkills.in. Till very recently and before the advent, we would have been mistaken for a lot of people in this country who think law kills. So thank God that the skills will now come about to change. That is one. Most important is what my learning has been throughout. When we started our practice, as Amit mentioned, about 30 years ago, we came to college. Of course, I had a fixed idea that I will practice law, unlike Amit, who was driven to it. But we did have an experience in college which wasn't really so education-oriented, in the sense that there were serious professors, there were some serious students, but most of us were sort of non-serious, and it wasn't really the way things sort of got institutionalized with the national law schools, which is now the pride of place for a lot of students passing out. That's the gap. The gap is, between what you learn theoretically in college, and then you step into the real world, and then you find that there is a difference, and that's what Manupatra is seeking to address, and I think I'll stick to the focus of just that, nothing more, which is that it is not possible or conceivable that in college, the 4 years or 5 years that you get, to be able to get a hands-on, full-fledged experience which helps you to hit the ground running the moment you pass out. That is not expected, that is not possible. The expectations might be too high, because good judgment or good practice or good efforts will come from really experience. So like they say, good judgment comes from experience, and experience comes from bad judgment. So you've committed, you've had a bad experience and you've decided badly, and that teaches you, and then you go on to improve. So really that's the life cycle, probably what Deepak mentioned also in his introductory note to all of us. But this gap is not unexpected, it is natural. So once you get into the real world, you will learn far more than what you did. And I thought that after having passed out, after college and after school and after college and more college, I was done with books, and I discovered that now I was beginning to study. So really the books became my companion, and I'd be immersed in dusty old books when we were researching, piled up in mountains of books, not the easy clicks that Deepak offers today through Manupatra and to a lot of you, and then you can go on, and he makes it easier for you to say which ones has been followed more, and what's the percentage of success, and how is this judge reported, how many judgments have come, and how many lawyers have appeared, and so on and so forth. But that we didn't have. But there was joy in what we did, because I remember each time I'd start to research on something, and we had a pile of AIRs at that time, or SCRs and SCCs which had begun. We would start reading and researching on one subject, and when we were reading that judgment, we'd suddenly remember that this actually, or some other judgment that follows it, was useful for another case that we were working on. So we'd quickly make a pencil note on another sheet of paper. So in the end, we took longer than what we had to, only for one decision, but it was very helpful. In that process, we started reading more, unlike what we're doing. And just as Mittal mentioned this, you click, you look at what is available, and you highlight and paste that, and lo and behold, you've got your researches, but really not so much of reading than researching. Which brings me to another learning that I did, and I think I should share with this. These are the tips that I think bridging the gap between what you learn and what you train and learn outside, which Mr. Nariman, I had the privilege of two things that he mentioned to me, which has stayed with me throughout my life so far. One is that, marshal your facts. Don't worry about the law will take its own course. So you needed to actually marshal your facts, read your brief, and be prepared with that. The second most important thing he said was, nurse your career. Always nurse your career wherever you are, whenever you are, and howsoever much that you've spent time. I still spend time in court, sitting, watching lawyers, watching judges, and making notes of what case law comes. And I think that's very important. And that second bit is what all of this is going to help us with. Nursing your career as you go along. And do not forget the fact, it's very difficult with the amount of judgments that are coming in every day. It's no longer easier for us to leaf through so many pages of reported judgments across different jurisdictions. Earlier, it used to be easy for us, just one trial court. High Court had a lot of jurisdiction on the original side, and then you could think about going to the Supreme Court, and that was it. But today, since 1990, as just Lokul mentioned also, we've had a varied experiences, different opportunities that have come our way. Regulatory sphere where I practice is a lot of areas, about 7 or 10 tribunals that I can think of, from telecom, the very first case that I did in broadcasting, energy, electricity, gas pipes, for example, gas lines, airports, competition, you name it. So there are so many of these. Each of those have extremely very, very important and focused specialized requirements of law that you have to meld with. But of course, it doesn't take away from the fact that you have to have your basic education and practice first, and then you go about specializing later. So those are the kind of opportunities that you have, which you need to constantly nurse. So therefore, you need to be able to understand how a telecom network works and how the different regulatory spheres also work, and can constantly put that in practice. So it's no longer generalized. You can't have a one-size-fit-all lawyer, and therefore you need to have all of these different modules that he has mentioned, which will help each according to your inclination. One other thing that Amit mentioned also, I noticed, and I must comment on that, and I think again, that's great insight and foresight that Deepak has had. He has priced this module about how to train with senior advocates the cheapest. Obviously, he knows there's not much that you can learn from them. So there's more value pursuing something else. So that's, I think it's a stellar effort, and I think I'm very happy that he's invited us to share this. Thank you very much.
May I now request Professor Vivekanandan for his perspective. Professor Vivekanandan is currently he's the founder dean of the Bennett School of Law, which is just going to commence the courses in law for degree. Professor.
Thank you, Mr. Raj. So after two people practicing, and then I would talk about from theory, from academics. So the central focus here of this product launch and revolving around this panel debate is about theory and practice. Are they juxtaposed, or is there the gap, and what do we do about that? Yogi Berra, one of the famous guy whose quote is often repeated is, in theory, there is no difference between theory and practice, in theory. But in practice, there is a difference. This is getting complicated. Or in other words, they even say, to put it simpler, theory is abstracted practice, and practice is applied theory, right? And this is not just for law, whether be it medicine, whether be it technology, everything, this question comes about this theory and practice gap. There will be a gap. The gap is narrower, it's healthy, but to wish away the gap is not possible, because as I said, that practice unfolds. So we cannot say that sometimes people even have the view that you don't really need theory, because if I understand this audience, I think all of us are graduates and above, right? But I see the latest billionaires in this world are people who are college dropouts and who had a garage of their father, that's all, right? So once you go post-graduation and above, the chances of becoming a billionaire becomes less and less in terms of the practical world what we are really looking. So, but if I really put it, what needs to be my view is this constant audit, or a kind of an osmosis or reverse osmosis of theory and practice have to keep taking place. And the effort of Manupatra in bringing in legal skills, right? And it's a very attractive, black and red color trademark they got. It's very interesting, because when I read the website name, I had a different, first I was a bit taken away, because it says, it says LawSkills is LawSkills, right? So sometimes laws can kill, and so if it is LawSkills, so at least you nicely put the trademark part differentiating that. So given all this, so where does, as I said, probably I was taking an angle. Why this practice part is so much missing is, I think, at least almost all law teachers, have not been in courts in many times. Most of them finish, they even try 1 year, and before they want to get into academics. And so probably I was even thinking that teachers need a module where they spend their sabbatical or some time to be in court sometime. And then when they come back, probably they will appreciate a lot of this gap between, theory and skills, what happens. And then they try to, do their structure, curriculum, etc. So that is one point of the story. As William Twining in his book on law and practice talks about the concept Pericles versus plumber. Pericles versus plumber is what he talks about, what you really do in theory and what you are practicing. But I wouldn't, as coming from academics, is not that, I'm a defender of, too much defender of a theory, but I would rather say that, as you say that the theory and practice, I would put it in a small experience, which I will tell that I was a couple of months in Japan for a research project, and then I was in my flat, and then that flat needs some plumbing things to be repaired. So I got a notice from the landlord, so-and-so, plumbers will come to your place. And of course, Japanese, they don't know English, but they brought English translation for me, right? What they are going to do, they explained to me through their English translation. And these guys were full of gadgets. They had everything with them, and they got some notebook, pad, and then the plan of the whole thing, and all things. And they explained in their best way in English, and they said everything will be all right. I said, fine. And then I went out and came in the evening, everything was all right, excellent. And then I came back to India, and a friend met me and said, you were in Japan, can you tell me how is the life and experience? I said, we cannot just speak in few minutes, and I myself was a couple of months in Japan. So I said, if you want it very short about Japan and India, I said in Japan, they work on know-how. In India, we work somehow, I said. Because my plumber comes, and he sits the pipe here, there, 3-4 places, and then, sir, I think, saab, yahan problem hai, says, and then he tries to do something. It works most of the time. But the point I'm trying to tell, with the Japanese plumber is 100% it works. Here, what we call as, plumber plus God's grace, all that will combine together. So this is where I am trying to tell, not to undermine theory, but at the same time, whether theory is stagnating, whether theory is frozen, whether if you have made a PowerPoint presentation, as we all call in academics, that is useful for you for next 3-4 years, change a little bit PowerPoint here and there. As they say earlier, they used to tell that, talk the chalk. And today it is PowerPoint and power nap. That seems to be the trend now with technologies. So this is where I thought. And as I pointed out, this not just for students help, as Professor Menon he started, I'm sure that he has more bullets on that regarding continuing legal education. I thought I will conclude with 2-3 points on that, on the continuing legal education. As very interesting, the Supreme Court, US Supreme Court Chief Justice Warren Burger once said that we lawyers are more casual about qualifying the people we allow to act as advocates in the courtroom than we are about licensing electricians, right? So this is what he himself said about what is this gap of theory and practice happening. So what happens? Either your theory is not up to the mark, or sometimes it's missed out, because we know legal education is not equal everywhere. If the resources are not equal, we are not going to take law schools and then make it as a kind of example, because they're so minuscule compared to many places. I'm sure that theory will be frozen in a big way. But if you really look at, then the only option comes for, once you even come out, and to update yourself. That has been, as I said, that this has to be a continuous process, and he was pointing out how it was mandatory once, and then it was removed, and then now we are realizing how it is mandatory again. Now at least your bar council exam has become mandatory, and this is going to be mandatory. So I think that this particular effort, what they have brought in is something what you call as, I will put it, they say the popular notion, ignorance of law is no excuse. In the same way, ignorance of development in law is also no excuse to tell that we didn't know the developments. So it is a continuous process, what has to be done. And to put it, as I said, not only I am just telling about skills, I always said that in another forum with Dr. Menon, I said the content and the container. The content is what you call as the whole legal system, etc. The container is the lawyer himself. And I think Dr. Menon's days, law schools were very different. And today, I shudder myself to be put in my timetable to go to the first hour in a law school. Because the first hour is the nap hour. All are sleeping on the first hour. By around tea break, 12 o'clock, they slowly try to understand in which environment we are there, and probably they get a little more aggressive by lunchtime. That is because I understood from Nalsar, my experience, that the average time they go to sleep is about somewhere between 4 o'clock in the morning and 5:30 in the morning. 4 to 5:30, that's the time we are getting up on the other side as teachers, right? Because we have a lot of things to do and come in. So that is a very important skill set of lawyer himself, because there's a lot of stress management here. You really find whether the lawyers have to be there, because today in US, you need to even undergo a course on that how you are keeping yourself. Because end of the day, as I said, lawyer is a means. And this whole skills, etc., is not actually to elevate the lawyer himself, but to keep the plight of the clients. It is end of the day, clients, because the popular saying, they say, only certainty about a legal system is the fee of the lawyer, right? The remaining you have to really improve upon. You really need a strong, CLE system. So if you really look at theory and practice, is not something opposite. It needs to be complementary. It needs to be complementary, and such complementary things, I am sure that the e-platform, which they have brought in here, could be of great help, and then it should improve and take up more suggestions. Thank you.
Thank you, Professor Vivekanandan. It's made important points, and essentially, it's really significant that particularly people in the West and in the advanced or developed countries, it's their attention to micro detail that actually puts them ahead, a step ahead, and all the time being concerned only with macro issues causes its own problems. May I now request the legend Professor Menon, who's run law schools in different parts of the country and continues to be associated with legal education in Cochin, for his views on the matter.
Thank you, sir. Let me put some thoughts as to how to address this issue of getting lawyers practice ready through law school education and through continuing education. Taking the cue from Mr. Kapoor's observation that at the end of the day, we have to ensure that justice is done, and the impact therefore is important, not that whether we need to do skilling or whether we need to do continuing education or we make lawyers technology savvy. The purpose is maximizing justice in society. From that point of view, I submit, it's an argument which has been canvassed for the last several years, that we need to change law education to justice education. After all, comparing with the medical profession, doctors are not primarily concerned with diseases. Doctors are concerned with health. Similarly, lawyers and judges are not just primarily concerned with disputes. They are concerned with justice. If that is the primary objective for which law and legal institutions are developed in civilized societies, legal education should address itself to the problems and the challenges concerning access to justice and the quality of justice. So theory and practice need to be appreciated in that context, which requires a fundamental curricular change and reassessing the objects of legal education. When the Advocates Act was framed, I assume the Bar Council was concerned with the singular objective of preparing litigators who can argue cases in the trial courts and appellate courts. If the Bar Council were to be asked what is the purpose of legal education today, it is not just merely to provide litigators. We want less and less litigation. So the object of legal education is to provide perhaps mediators, conciliators, arbitrators who do not litigate, who would try to address the problems of people and see that justice is done by conciliation, negotiation, and arbitration and similar things. Similarly, we need to use legal education to prepare and address the economy, the challenges in the economy, challenges in the polity, and things like. If that is the purpose, then skilling will also have to take note of this change in the objects of legal education. So we may perhaps have to start thinking from that and not just address the question, existing system of dispute resolution in the court. How do you tackle senior advocates, engage them, or how do you prepare the trial advocates to cross-examine? Because there are many ways of extracting the truth other than cross-examination. It was once upon a time when people used to tell the truth in court on the basis of their oath. They feared God, and they used to tell the truth. But today it is different. The methods of finding the truth are far more different than the time when this Anglo-Saxon jurisprudence discovered the adversarial method of finding facts and administering justice. So the objects of legal education is to maximize justice in society, and from that point of view, we need to blend theory and practice, and that is my point number one. My point number two is that this effort of the Manupatra can be linked to strengthen the system of legal education in the colleges which teach law. I recall a judgment of the Madras High Court in February 2016, last year, wherein the court asked the Bar Council to distinguish professional legal education from academic and liberal legal education, and be concerned only with professional education. Leave the academic and liberal education to universities and colleges. It can be 1 year, it can be 2 years, it can be 5 years, 10 years, whatever. It can be through distance education. You are not concerned. You are concerned only with legal practitioners, whether they are mediators or arbitrators or litigators, what have you. If you are only concerned with that, out of the 1400 law colleges today, to my mind, not more than 500 colleges will qualify as professional law schools. And the skill or skilling is essentially required for these 500 law schools, not the students of the 1400 law schools. If the students on the academic stream want to come to the professional stream, yes, you can have a bridge course, giving the necessary skills to them to be able to come to the profession. That means you need a structural change, curricular change as well as a structural change. And if you were to do that, I have a solution wherein the professional colleges can combine theory and skills in such a manner that he or she may be more practice ready than he or she is today. And that is, what is that? My submission is that in the 5-year LL.B program, all that required courses, compulsory courses, 25 of them prescribed by the Bar Council, as well as the optional courses, the theory part of it, the classroom learning, can be completed in 4 years. And the 5th year is entirely devoted to hands-on experiential learning. And that depending on the career choice of the student. Okay, I want to be a litigator. What are the skill sets that you are in need? The language and communication skills, the drafting, pleading skills, the oral advocacy skills, the evidentiary issues, etc. So you need to prepare in a lawyer's chamber and in a courtroom 1 full year. In some cases, you may yourself be arguing counsel. In a consumer court, you don't need a license to be an advocate in a consumer forum. And you do some of those things which a lawyer does. Many other paralegal work you will do. So that at the end of the 5th year, with 1 year full experience in different law chambers and courts, you will be combining that theory and practice in such a manner that you will be more practice ready. Okay, you want to be a corporate lawyer. That means you are to draft contracts, you are to work on mergers and acquisitions, you have to do a variety of transactions. Okay, send him to Luthra and Luthra or Amarchand Mangaldas or other place 1 full year as a trainee under the supervision with courses which are structured by the law school in consultation with the corporate firm. And for 800 marks, 8 papers, practical training, so that it will not be taken casually. And you are examined on that, and then you prepare yourself a good transaction corporate lawyer. Or if you want to be in the judicial service or civil service, the 5th year can be prepared on policy development, on various other issues of research and reform in civil services or administration or judicial management in the judiciary, a number of things on which you can prepare. Today the legal profession is not one profession, it's multiple professions. Because I don't see many things in common between a mediator and a litigator. Tell me if there is something in common. Both in theory and in skills. We have to change not only skills and attitudes, but also ethics. The ethics of a mediator is widely different from the ethics of the litigator. Very little that is written in the Bar Council Code of Ethics apply to mediators. And they need totally different things. So it's a different profession. Similarly, the corporate lawyer, the in-house lawyer, the guy who is doing legal process outsourcing, the guy who is legislative drafting, they are all lawyers. But the legislative drafting fellow, what are the skills that he needs? Today we don't have draftsmen. So the skill sets will have to be identified in terms of the career choice of the lawyer. And then this 1 year will have to be utilized to instill in him the fundamentals, both theory and practice, of how to develop your career, in that regard. And finally, I submit that law schools, good law schools, professional law schools, should be incubating future legal practitioners. And this can be done in association with the Legal Service Authority, in association with law firms, in association with government law departments, with regulatory agencies. And this partnership, not merely with industry, but with government as well as the judiciary, you will be able to develop a profession which can be globally competitive. Because we are talking, very soon we may have transnational legal practitioners. You will be comfortable to negotiate a contract with the Japanese, or with the Germans, or with the Americans, and each is a different ball game. If you were to prepare yourself to be a global leader in economy, naturally you have to be comfortable with transnational legal practice. Today, the government, I understand, if you want to have an economic enterprise where technology transfer, etc., you engage British barristers. Government of India does that. As if there is no talent available in the country. Perhaps there is no talent. That's because the profession is not prepared. They know only litigating and litigating. Thank you.
Thank you very much, Professor Menon. Useful thoughts from there. May I now request Mr. Kailash
Thank you so much. I'd also like to add my name to one of the numerous disciples of Professor Madhava Menon. He taught me in National Law School for a while.
Yeah, Kailash.
And I think enough points have been made right from Honorable Justice Lokur to everyone else on the panel in terms of why it's so important from a legal stakeholder system. I'll restrict my comments to talking about the medium and the platform of this type of online education, and try to share what I view are some of the challenges and opportunities. The concept of massively open online courses is not new. It's especially very popular in the US. There was a big fad over it, as early as 10 years ago. The advantage I think that Manupatra has and other players who want to enter this important training area is that they can learn from some of the mistakes, what what is being found in countries like the US is that the economics has its own challenges, the ability to run and sustain in terms of paying the creators of content, people who deliver the content. There are challenges around the economics. There are also issues in terms of making it accessible and affordable, and maybe the state and Bar Council can play a role in providing subsidies. When it comes to delivery of any type of education online, and a lot of experiments have been going on, is that the skill sets that are required are actually quite different from the normal education instruction in a classroom setting because of the constraints in which the medium is presented. In fact, one of the most popular courses on this platform called Coursera is Learning How to Learn, and that talks about how it's important to balance very rigorous instruction with periods of reflection, so that maximum education is when you challenge the student, also you allow them time to reflect, converse on the platform, talk to each other, talk to the faculty. And the conversation is actually a very important element of the platform, and I noted that they have a discussion forum in Manupatra. Students can discuss with each other, reflect on the class, they can discuss with the instructor, and a lot of the learning actually happens as a part of that interaction. The other great thing about this, and it's actually very disruptive, is not only does it disrupt the barriers of distance, and particularly making this type of knowledge accessible to Tier 2 and Tier 3 cities, lawyers and others there. It's also disruptive in the sense that it can be synchronous and asynchronous as well. So you can have a real-time, there's a judgment which comes from the Supreme Court, which has an immediate implication on, say, taxation, and you can immediately launch a talk or a session and get comments at the same time. But it's also possible for you to look at an issue which is, say, 10 years old, it could be a death penalty case, and go in and have an asynchronous discussion, revive, talk about it on a forum where people's time is not important. The real-time presence of the person is not important. So you can have a conversation without having to be present with the person you're talking to. So that's a very powerful way of learning and distributing knowledge and skills. The other thing I think which is going to be very important is also to see how you can use machine learning. So this is presumably using cloud resources. You're going to use cloud computing resources. So you can also talk, suppose you are specializing in a particular type of law, you're looking at administrative law, you're looking at law which concerns the Armed Forces Tribunal, and you find some colleagues, some other people who are taking courses, you get to know what courses they are taking, right? And then the platform itself can suggest courses depending on your interest. So there's a very powerful feedback tool which can help learners on this. And it's also empowering for people who want certain degree of privacy. If you feel you're not adequately equipped, but you don't want to necessarily walk into a classroom and show your peers that you're not equipped, I think it gives a certain sense of privacy in which you can do it. And this can extend to forums where you want to keep close forums. So in forums, if there is a high court or a judicial body where the members of the judicial body want to have a very close discussion, for obvious reasons, or it could be about a case. And I think technology can create the degree of security in ensuring that you're able to have the education in a way in which you're comfortable with. So I think these are some of the points. I think the last point that I'd like to end with is that in my previous role, when I was working in Microsoft, we have a very important training called Standards of Business Conduct, which basically talks about how important it is for employees to act with ethics, respect local law in whatever jurisdiction you're operating in. And this course was entirely delivered online. It was delivered online, it was flexible, but it was also successful because the leadership in the organization talked about it, and it became a badge of honor for any department to say, we finished the ethics and compliance training first, and we've got 100% compliance. So I think it's important to evangelize this beyond it, and maybe some courses create a fad around the course and get those people to talk about it. I'll end with that. Thank you so much.
Thanks, Kailash. Thank you very much. I think we've got views from all our panelists, drawn from their experiences as well as interacting with the profession. I'm extremely conscious of the fact that we are perhaps overrunning the time a bit, but we still have 10 minutes for interactions from the audience, and grateful if people keep their questions short and succinct, and if they would like any particular panelist to answer that. The floor is now open.
I am Dr. Pallavi Gupta from James School of Law, Greater Noida, affiliated to GJS IP University. My question is to Professor Menon. What kind of skills are required for free legal services to the community beside legal aid awareness camp and Nukkad Natak?
Okay, thanks. I'll take a couple of more questions. Yes, sir.
Good afternoon.
Yeah.
My name is Hannan Ahmad. And sir, I have a very simple and basic question related to FIR that lost in the police station.
Ji.
For a petty to pettiest crime, whenever anybody goes to the police station, the constable applies at least 8 to 10 CRPC and IPC for a pettiest crime, sir. Even I booked for that, for a small argument, and I indulged 11 years. So do you have any solution to educate the police system or that sitting particular constable?
Okay, thanks.
And sir, second question to Mr. Menon.
Can we go one at a time, please?
Okay. Thank you. Thank you.
Mr. Libahan, I think there's one question we've received online which is
Yeah.
quite relevant in that context. It is that we talk about the modernization of legal education, but where do we stand on the modernization of the investigation and the legal education system pertaining to investigations?
Okay. I think I request Mr. Ramji Srinivasan to respond to that part. We'll take perhaps one more question. Yes, sir.
My suggestion to Mr. Madhavan is that every law college in the country must be attached with some district courts so that they may get the practical experience.
Good idea. Thank you. Thank you.
Myself, Sunil Astogi, Chartered
Yeah.
Accountant and
Yeah.
LL.B. also.
Yeah.
Respected Menon-ji mentioned that there should be ethical practice. As there are so many corporate lawyers and advocates who are making money instead of giving justice. So, sir, I just want to ask whether there should be any platform which provide ethical education, which provide justice instead of making money. There are so many corporate lawyers who are charging very high amount of fees.
Okay, we got the idea. Thank you.
Just ask.
I think we'll just get the response.
Well, corporate lawyers also contribute to justice in society. If you analyze the impact of the work that they do to promote rule of law in the economy and also to ensure compliance with the various requirements of labor law, environmental law, this, that and the other, you will find that they are doing a public good as well. Lawyering is a public good, unlike business education, which is a private good. Lawyering involves, even in a private dispute, the public interest. Every case decided by the court has some public interest dimension. So from that perspective, don't dismiss that corporate lawyers are making only money and not contributing to maximization of justice in society. The colleges need to be attached with law executing institutions, including courts. Well, they can be attached with various administrative bodies as well. It is supposed to be doing like that, but the way it has developed and the control of the Bar Council has been too remote and not very effective. With the result, they have turned themselves into teaching shops. That is why I appreciate the Madras High Court judgment, where they said that you have to separate professional legal education from academic and liberal legal education. So professional law schools can be attached with all those institutions in government as well as in the administration of justice, so that theory and practice can be blended while they are students. This police and investigation, we need to address this question. If suppose Manupatra were to give emphasis on criminal justice rather than going on IPR and which is market demand. But if you were to address what he's mentioned, the second tier and the third tier lawyers who are in the municip's court, magistrates court, etc. The biggest problem in India is in the area of criminal justice administration, where the poor suffer the most, the underprivileged, the weaker section, the women suffer the most, children suffer the most. It is in the criminal justice system. And the criminal justice system need to be looked into with police. Police will have to be taken as legal practitioners. When they investigate under the provisions of the Constitution and the Criminal Procedure Code, they are really practicing law. When they prepare an FIR, when they prepare a 173 report, really they are drafting legal documents. So therefore you need to have a larger concept of lawyering than people with a black coat and a gown. So when corporate lawyers, we talk about people working in this corporate sector, we need to include the police also into the criminal justice administration. And then this must be, I think Manupatra's program will be useful in the police training colleges as well, sure, if you develop that program.
Thank you. Mr. Srinivas.
Well, just quickly to add to what Professor Menon has mentioned. I think the question really was that from a practical perspective, you find that when you register FIRs, the local constable or the police station registers an FIR with multiple provisions, legal provisions, which have been mentioned therein, whether it's of IPC or CRPC. That is part of the training or the lack of it, which the constable receives in terms of education. So as Professor Menon rightly mentioned, the police is part of the criminal justice system. So it touches upon the everyday person right to the grassroots level. So it is the knowledge that, say, an online platform like Manupatra, that's exactly what I was going to suggest also, is that making it simple, not just in terms of everyday education, divorce, custody, and things like other modules that I've seen also, on criminal justice also, on how to register an FIR, how to recognize basic offenses, which we know, most of them have a pattern. So you know that there is assault, there is attack, there are a few other things, robbery, there is a theft, things like this which touch the basic offenses. A large variety or majority of them should be made part of a basic course which is priced very reasonably, and then that will be something that a lot of people, especially because it is available in vernacular, will be a very, very popular and a service that certainly Manupatra should serve. But I think there should also be an effort for you, perhaps, and this is my suggestion again, is to promote this module amongst the investigative departments and the police department, that they must make it mandatory, that each of the police officials must undertake this as a continuing requirement, and that they must clear that also. So that will help as they are part of it, so they register it correctly. The second thing would be, of course, that you make it transparent. So if FIRs are lodged which are without reference to actual offenses, and they are very convoluted, making them transparent, uploaded to the system, and making it available to the person would also create awareness. Namely, they can go back and check whether this is correctly recorded or not. I think that's really the effort that we can discuss in this particular forum.
Thank you very much. I think we've come to the end of this panel discussion. Maybe before we close, I could request my fellow panelists with any one last thought they'd like to share with the audience here. Anything, Kailash? Professor Menon? Professor Vivekanand? Anything on this issue?
Yeah, one of the things I dealt last 15 years is running a course on various diplomas. We even named it as proximate education instead of distance education, because we thought we are in the age of internet. So in that, one interesting statistics I found, we gave both the choices, that people can do online, everything is online in the sense modules, everything, and we also conducted contact classes in different cities. But when we analyzed a lot of results, the people who attended contact classes face to face, whether it's a question I saw in the slide, they were faring very better. Relatively, I'm not telling the others are not faring. Because at least I thought, I don't know whether it's learning a computer program through online is different from learning the nuances of legal education face to face, and the dynamics changes where they come and one person asks a question, the other person never thought about it, and then this is the dynamics what we saw. These results, we just did a statistical analysis that how many are passing and doing well, and did they attend contact class because of the attendance sheet. So in one sense I want to tell that at times this is a great supplement, that online, e-portal, etc. But as I said, traditionally it doesn't replace what you really learn in a different dynamics. So if you don't have that opportunity, or you don't have that kind of resources and teachers, this is going to be, you know, a great leveler, I would call it. But at the same time, that we need to, as you know, Karthikeyan was putting, and there are a lot of challenges, that this good theoretical online models, and then how does it reach in different geographical and strata, needs to be a constant feedback to the promoters of this e-platform. Thank you.
Thank you.
Just a very, very quick comment. This is a great advantage today because we are taking advantage of technology. Therefore, we have to go to education. Education is now coming to us. And therefore, this is, as Professor Vivekanandan mentioned, a supplement. It's no replacement whatsoever. And I would suggest, and I'm very glad, and I'd be very happy to undertake something like this, which came to me once in 6 months, or once a year, or once in 2 years, that I had to mandatorily undergo a very basic refresher course, and then therefore that would be mandated to each lawyer. So lawyers don't have to go. And the chartered accountants, for example, I've had occasion to appear for the institute also, where there was a challenge to whether chartered accountants should be also required. They are required to also undertake, and they have to undertake refresher courses every year. So therefore, if this were made mandatory by the bar, or continuing on the resolution that was passed 20 years ago, then a simple thing like this would help us review, and for lawyers it's extremely important apart from all the other students. And that will be very welcome.
We have covered a lot of ground, but I would like to end just with a quote. And a famous author, I won't name him, let's see how you know it, said, "Never let your schooling interfere with your education." So it's the practical training which Professor Menon used to teach us in Law Fac way back. Is actually the essence of getting to justice rather than delivering solutions as lawyers and members of the legal fraternity, which don't have meaning to the people in public. Thank you.
Yes, as they say, life is what happens after all the planning has been done. We've got sort of many ideas from this platform, and I'd like to thank all my panelists for having transparently shared their experiences, the difficulties that they faced initial years, and how they would like to see the environment addressed on the whole question of legal education, continuing into the professionals at definite intervals. Thank you very much, fellow panelists, and I'd like to wish Manupatra all the best with this initiative. It's a great initiative that's been undertaken, and I'm sure it's going to get more and more relevant. Perhaps they can even consider writing, Justice Lokur mentioned in the morning that law has to be also seen in the social context. And access to justice is a huge, huge deficit that we witness, we hear stories, we'll sort of see every day, and to look at how access to justice can also be facilitated riding on this platform. Thank you very much. Thank you very much, Manupatra, for getting it.